May it please the court, counsel. My name is Ashley Stewart, and I'm the attorney for Levi Gibbs III. Iowa Code Section 704.2b violates the Fifth Amendment of the United States Constitution and Article 1, Section 9 of the Iowa Constitution because it compels self-incriminating statements and it restricts the right to use a justification defense. So in order to determine if the statute violates the Fifth Amendment, we have some factors that we have to look at. First is whether the statute creates a risk of self-incrimination. And here, 704.2b does just that. It asks a person to go and tell law enforcement, an investigatory body, whether they used whether they used deadly force.
Yeah, but if you use a self-defense aren't you saying I did it, but I was justified in doing it?
You are.
How is it any different than having to go tell the law enforcement earlier or stand up in open court and say, I shot the person, but I have a defense? What's the difference?
Well, the key difference is once you are charged and you get to trial, of course you've already been suspected of using deadly force. However, by the time 704.2b comes in, or when 704.2b comes into play, you might not be under suspicion. So it's requiring you to go to law enforcement and tell them that you possibly committed a crime, i.e. murder, manslaughter, and even if there wasn't a murder, you still use deadly force, so maybe it's just assault, or maybe it's a lesser crime like possession of a deadly weapon in the arms of a felon.
What is the compulsion that the statute requires?
So it requires you, again, to report to the police. I think the compulsion comes in because it's part of a statutory scheme. So even though there's no punishment...
Would you agree there's no punishment for this?
Yes.
And that this defendant wasn't prosecuted for failing to report? The failure to report was just an instruction that was given during the course of trial. Is that correct?
It was an instruction, but I would argue that it was actually used in his prosecution because the state did argue that because he failed in his duty to follow 704.2b, then he didn't have a justification.
So the compulsion, at least as I understand it, the argument you're making, is that the additional, I guess, psychological pressure from giving the instruction would compel testimony. That's essentially it, correct?
That's part of it, and I think the other part is 704b 2b is still attached to that statutory scheme. So it falls in line with the murder statute, the manslaughter statute. So when you go and report to the police, you are still you're subjecting yourself to be punished by these other statutes, and that also creates the compulsion.
I think there's some potential merit to your argument. If I draw an analogy, if the legislature passed a statute that says if somebody dies, you have to go to the police and give an explanation, and then you instructed the jury that this person had not given an explanation, that would be a clear Griffin violation, right?
Yes, it would.
And this is kind of an analogy, right?
It is, yes.
I've got another comparison. How about in an OWI case when somebody chooses, I think it's, I can't remember what it's code section, 321J point something, where you're offered a breath test, but you don't have to take it. But when it comes time for trial, if you refused it, that can be included in a jury instruction.
I think the difference here is that there's a duty. That's what the statute is saying, that you have a duty to go to law enforcement and report. And the argument here was because he didn't follow that duty that's prescribed by the statute, he doesn't get a right to a justification defense.
How about if the statute was softened just a bit to encourage people to do that, and then it was used as a jury instruction? Would you have a problem with that?
I would. I think it would be the same outcome.
And how would that be any different than that 321J example I gave you?
Again, I think there's some compulsion here because it's saying that if you don't, then you don't get a justification defense. It doesn't say that for the OWI.
But he still gets the justification defense.
I think
that's an incorrect statement.
Well, my argument is it did restrict and take away the justification defense. That's how it was used at trial. It was used to say...
But was he able to present the defense?
He was able to...
And the jury was instructed on the defense.
They were, but then they were also instructed that since he didn't quite follow the duty, they could ignore the justification defense.
How would this conduct be different than any other post-offense conduct that we would say may or may not be relevant, but it's a question of evidence? So, for example, we have cases involving flight and we say defendant's post-offense conduct flight may be relevant. Destruction of evidence, tampering with witnesses, leaving the state, whatever the issue is, our case law indicates that those are evidentiary questions. Why is this different than, say, for example, a flight case?
So again, I think the main part of this is that it restricts and it makes it where the defendant has to go and tell the police. That's the difference. There's a compulsion factor tied to this statute. But in the ordinary self-defense case, where somebody kills somebody, they don't turn themselves in, they don't go to the police, they don't, before this statute I'm saying, they don't do any of that stuff. And then they get charged, they go to court, and then they raise the self-defense instruction at court. Isn't it normal procedure for the county attorney to argue that, well, if it was self-defense, why didn't he go to the police right away and report it? Why did he go hide and we had to arrest him and investigate it? If it was really self-defense, there was no reason to be afraid of reporting the crime originally. And all this statute does, and if it's correct, and I'm not sure it's correct or not because it creates an inference if you don't say it, you don't have the defense, but it's no different from the argument that prosecutors make all the time. If it's really self-defense, why did this person abscond? So how's it any different? I think it's different, and it's going to sound slightly repetitive, but I think it's different because in those cases, there's not an argument, there's not a statute that says there's a duty to do it, and if you don't get that justification defense. And I think that's where this case falls. It's really about whether the jury was or compulsion, and then at trial, whether the use of the statute as a jury instruction rendered it where he wouldn't be able to use his justification defense.
To follow up on Justice Wiggins' question, let's assume that the district court declined the instruction in this case, but still the prosecutor argued that, as Justice Wiggins asked, well, if this is self-defense, why didn't he report? If this was self-defense, why did he sit in 2 police interviews and deny that he was even the shooter? Would those have been impermissible arguments for the prosecutor to make absent the instruction?
Well, I think currently Iowa law doesn't really answer that. There's been no cases that have come to the Supreme Court, but I do think that if you look at the federal law, it's a little bit where they say that you can't use pre-silence, pre-Miranda statements against a defendant, and I think that's where this would fall.
Yeah, there's a difference between conduct, which some of the questions have asked about, or the scenario where the defendant makes a statement voluntarily but doesn't raise self-defense, and then the situation like here where the state is trying to get the jury to draw an adverse inference from silence, right? Isn't that different?
So you're asking me if it's different between silence and actual conduct?
Yeah, it's a friendly question.
Yes, yes, and I agree with you that it's different. Thank you.
So let me follow up with an unfriendly question then. So in Salinas, the court says that there's no violation of the right until there's an invocation.
Yes.
Right? And in that case, you have a defendant who's sitting in an interview with a police officer, and in the prosecutor's case in chief, they admit the defendant's silence in response to very specific questions, saying there's no invocation of the right. So if the Supreme Court's indicated that there has to be some sort of affirmative invocation of the right, wouldn't the defendant's silence prior to some sort of police interview, whether it's failure to report, whether it's denial of involvement during the first interview that occurs, I think, at the dining room table or wherever that is. So how do you overcome the invocation holding of Salinas? Well,
obviously, here in Iowa, under the Iowa Constitution, you don't have to align yourself with Salinas. And I think Salinas is a Texas case, but you pointed out some of the differences. Salinas went in voluntarily after he was already under suspicion. Here, Iowa the 7042B statute would say that you have to go in before police even suspect you. And then I think you can find that silence is invoking your right, invoking your Fifth Amendment right. Also, in order to find compulsion, you have to make sure that the statute creates a real risk for self-incrimination. Here it does. Because, again, you have to go into the police, you have to let them know that you committed a crime, and inform them that it happened. And that then leads to the third step. It creates a link in the chain to potentially prosecute you for something. It goes back to that statutory scheme. If I go to police and I tell them that I use deadly force, I'm now subjecting myself to be penalized under the statutes we have here in Iowa. And so for all of those reasons, it falls in line with Albertson, where there is compulsion attached to 704-2B.
I'm having a hard time following your argument that you say if you don't invoke the 704.2B, you can't use justification. Where does it say that?
So in 704-2B, it doesn't say that, but it was used in this case to indicate that because Mr. Gibbs did not follow 704-2B, he wasn't allowed to use his justification defense. That's what was said to the jury, and that's what could have been inferred from it.
Is there a case that you can cite that holds a statute violates the Fifth Amendment when there's no penalty provision attached to it? So all the cases you're citing, Albertson, Marchetti, Grosso, those are all criminal prosecutions or contempt prosecutions where there's an actual penalty imposed. So what case holds a statute is unconstitutional where there's no penalty provision?
So I didn't find that case. I do think that this case closely does align with Albertson, though. In Albertson, as you know, if you're a member of the Communist Party, you had to fill out paperwork and give it to, by statute. And when they didn't, there was a petition in the court to make them complete the statute. And then when they didn't, then it went to the court. And I think part of what the court said there was even though with Albertson, all he could do was try to make them fill out the forms, they were then subjected to other parts of a statutory scheme that they could get punished for being communist. And it closely aligned with that in the fact that even though there's no punishment, there's still punishment under other statutes here in Iowa.
But you say the defendant didn't get a justification instruction, but he received one here.
He did get a justification instruction. Right.
So all he did was get those other instructions, which I don't know if they're right or wrong, saying that he didn't follow a statutory duty. But he still got his justification instruction, and whether he followed the duty or not followed the duty under those statutes, the jury was still able to find justification if the state failed to prove it wasn't justified. If the state failed to prove that justification wasn't a defense.
Well, my argument here is if you couple that statute with the arguments made by the state, then it in effect did alleviate the state from having to prove justification, and it took the right of the defendant to argue justification away from him.
And I don't think there's a lot of time left, but the state also makes a harmless error argument. Could you respond to that?
And so as far as harmless error, I think there are several factors that you have to analyze to get to determine if harmless error was used. And the first is the use in which the state argues the silence. And here, what they argued again was that because he was silent and didn't follow the duty, then he didn't have the justification defense. And when you take away a key element that the state has to prove from the state, that means there's a due process violation and it's not harmless error. And so I think when you look at that, that's what creates the harm. That's what creates the harm, and that there is an error.
And if you claim self-defense, who has the burden in that respect?
Well, the state has the burden still to prove lack of self-defense, but
the defendant would need to put on evidence to support his claim of self-defense, or he doesn't get that jury instruction, correct?
I would agree.
Does our decision in Herrera, a civil forfeiture case, help you in that we held that there was a valid Fifth Amendment objection? You didn't have to follow the statute that required somebody who wanted to get money back that had been seized to plead where they got it, which potentially was incriminating. And we upheld a Fifth Amendment challenge to that. Didn't impose it. I mean, the implication was you couldn't get something you were entitled to without incriminating yourself, and so we excused the claimants from pleading that. Does that help you?
It does. I think that's the same argument. It precluded Mr. Gibbs from using his justification defense, and therefore it was violated the Fifth Amendment.
But if it was truly justification, you're not incriminating yourself because you didn't commit a crime. Because it's not a crime to kill somebody if you had a justification or a legal defense.
But we know the police might not always agree with you, so it doesn't necessarily mean it would lead to a conviction. It just means that you're being compelled to place yourself in a position where you can be investigated and charged. And that's what this does. No further questions, and my time is up. Thank you.
Ms. Stewart, thank you as well. Mr. Howell, you may present your argument.
Thank you, Your Honor. May it please the Court, Counsel. Good morning. Counsel and I fundamentally disagree about Iowa Code Section 7042B. The statute is neither compulsory nor is it requiring self-incriminating admissions. As you point out, Justice Wiggins, an individual who is justified in their use of deadly force has committed no crime in this state.
Well, but once he got that instruction, he was finished on the justification defense. I mean, if the instruction is very powerful under the facts of the case, he did not, I mean, it's undisputed in the record, he did not report under the statute. And so once the instruction was made, the environment for his justification defense was dramatically impacted. Don't you agree with that?
I don't, Your Honor, and I disagree for a couple of reasons. The first is I don't think it was necessarily the death knell of his defense, as it's been pointed out by multiple justices.
Knell. I mean, he got to argue it. Maybe
he certainly
not death
did.
Knell,
And
but my heavens, I mean, it says you have a duty to report, and then in closing argument, the prosecutor's all over it. So I mean, I agree with you. Yes, could he make the justification defense? Correct. Mm-hmm. But this instruction really took advantage of the fact that he was silent pre-Miranda.
Well, I would again disagree with your depiction of the prosecutor's comments. The prosecutor, in closing argument and rebuttal, did not talk about silence. He talked about conduct. Mr. Gibbs's conduct in this case is not, I mean, it would have to be a constructive silence at best. Lying to police officers.
I mean, conduct that he didn't talk?
Conduct that he fled the state. I mean, all of these acts of conduct are things that we would have no trouble with admitting in the state's case in chief and talking about in closing argument and rebuttal. There's no error there, which goes in turn to why I think that the district court took the straight and narrow path in this case. This was undoubtedly the law at the time of Mr. Gibbs's trial. The district court added no flourish. It simply instructed about what the duty was and left the jury to decide whether or not he complied with that duty and what impact that might have on his defense.
Does the state have the right to remove the justification defense from murder?
Just as a matter of statute.
A matter of law. Can they pass a statute? We are not going to recognize the self-defense as a justification for murder.
I don't believe so. I think there is a constitutional right to self-preservation, which would include some essentially restricting what the state could do in terms of limiting that defense. But undoubtedly, the legislature can put on certain requirements. For example, alibi.
But if they put on a requirement that causes you to incriminate yourself, that's not right. And you'd agree with that, I take it.
Well, it presumes a certain number of factual predicates.
I'm just saying, in the abstract, if it requires you to incriminate yourself, it probably can't be a condition of the self-defense. I mean, you're saying this doesn't incriminate you and a whole bunch of things, but sure. if they require you to incriminate yourself, then they can't do that if there is some kind of right to have a self-defense.
So to answer your question, you're correct. The state could not create a law that required someone to incriminate themselves or face penal sanction. However, I mean, as Mr. Gibbs did in this case, you're not required to disclose your murder to the state. There might be subsequent consequences for that, but that's no different than your substantive act. I don't see...
What if the statute read, a person using deadly force is required to waive his or her Miranda rights and give a full interview once arrested by the authorities? Would that violate the Fifth Amendment?
Once arrested by the authorities, I would agree that would violate the Fifth Amendment for a couple of reasons, as I'm sure intimating, which is that the right to Miranda has attached. But there's a tension.
But the right is not to Miranda. The right is the Fifth Amendment, and the Fifth Amendment always applies. I mean, there's always a right to remain silent and not to incriminate yourself by statements as opposed to conduct.
I take your question well, but the problem is that it is permissible for the legislature to create requirements on the use of affirmative defense. That's what we learned from Williams from the United States Supreme Court.
And, you know, that might be a different case, actually, if they had said, in order to get a justification defense, in order for a defendant to have a justification defense, assuming we get past this constitutional issue of whether the defense is constitutionally protected. If they said, in order to get a justification defense, you must notify law enforcement within so many hours, blah, blah, blah. But that's not what happened here. What happened here is Gibbs is raising the justification defense, and the jury is now being told you should draw an adverse inference because he didn't talk to the authorities. And that's the problem I have.
I understand your concern, but again, harmless error in this case would undoubtedly suggest that no reversible error occurred, nor any constitutional violation, given the conduct that Gibbs engaged in. Handing a phone and representing it to officers that it was there the night of the murder, fleeing Fort Dodge, lying to police that he didn't have a gun and didn't shoot the individual. I take your point. I don't see how it would require a different outcome here, especially when I don't believe either a categorical challenge to the statute was preserved, nor do I think an as-applied challenge could sit, given the facts of this case.
If we were to agree with the defendant here, how would that work as a practical matter? So you saw the police interview. If the officer asks, was this self-defense? Did you shoot this person? Here, Gibbs says, no, I didn't shoot him, even though he's on tape shooting the guy. Is that silence because he hasn't reported that he shot somebody? Is that a statement that could be admissible? How do we parse between those kinds of issues where he's ineffective, he's effectively being silent because he's falsifying, or he's at least
being
not admitting
constructively
to
silent. You might say.
Yeah, constructive. How do we parse through that?
So I think that's an instance when Salina and Minnesota versus Murphy become critical, which is that in order to rely on your rights under the Fifth Amendment, you must invoke them. You can't fabricate things. You can't sit quietly by as police officers ask you questions. If you intend to rely on your rights under the Fifth Amendment, you simply say, I don't wish to speak to you. I would like to terminate this conversation.
Is that a plurality opinion of the Supreme Court?
Salinas was, but the additional members of the court suggested that they didn't believe the Fifth Amendment attached at all at that instance. That would be Justice Scalia.
But it's not really clear whether that's good law, that some pro se independent person has to know pre-Miranda to invoke the Fifth Amendment right.
Well, Your Honor, as they mentioned in Murphy, every schoolboy knows the phrase, if not the content of the Fifth Amendment. It's not so hard to imagine that an individual, and the circuit split on invocations demonstrates that people do know.
Circuit split, the majority go against you, I think, and then there's a few that go with you. And the state courts generally tend to say the Fifth Amendment does apply pre-Miranda without invocation.
Well, and again, in the majority of the cases from the circuit split, there is an explicit invocation or a statement to the effect that I don't wish to speak with you, officer. And that's different from this case. And that, again, represents why this is a poor test case to resolve this question. I would note in a couple of the other mandatory reporting cases, the statute can be saved in an instance where anonymity is involved. If we look at 704-2B and we're pressed under potentially invalidating the statute, it could be saved by stating that an individual must contact police but need not provide their identity. But again, I think the statute is intended to serve a number of purposes, not for self-incrimination purposes, but to bring a violent incident to police attention, to potentially provide medical attention to an individual who might require it after the use of potentially deadly force, but not necessarily. I don't see how this is compulsory when an individual may simply remain silent and hope the police never discover the incident.
I'm a little troubled by the argument of the state saying that it's a statute. The trial, or excuse me, the jury instruction pretty much followed it verbatim. I don't think there's any dispute to that. And defense is saying it caused an undue inference, and you're arguing it doesn't. So then why use it? if you can use all of those other examples of where you think the defendant has maybe shown actions, ran away, didn't admit it, just to me seems like you're complicating things. I think the defendant's argument that it's being used to pressure your case in a positive way is actually supported by the fact that you used it.
Well, I would like to assuage your concern, Justice Christensen, and I think there are a number of jury instructions that provide permissible inferences to a jury that might impact a defendant's decision to remain silent or non-silent at trial. However, we permit them. For example, that a deadly weapon may be used to infer the requisite malice for murder. Certainly that benefits the state's case, but it doesn't impermissibly affect the outcome of the proceeding. As you've pointed out yourself, we allow district courts to instruct on a failure to comply with OWI testing. It certainly doesn't look great for a defendant who does that, but it's not impermissible. The legislature can, in an attempt to reach rational outcomes, can make requirements and permit inferences and instructions at jury trials.
Does the Herrera case provide guidance for us?
I know you just spoke about Herrera, Justice Waterman. If you could bring me back up to speed for a second.
So it's a statutory requirement that a claimant seeking return of property seized in a civil forfeiture proceeding must identify where they got it from. And in that case, the defendant didn't want to reveal the source of this cash.
Certainly.
And we upheld his Fifth Amendment objection and allowed his claim for return of the money to proceed without him identifying, as required by the statute, where he got the money.
Sure. It's informative in a couple of respects. One, it's informative that Mr. Herrera, it sounds like, actually invoked the Fifth Amendment in attempting to recoup his cash, which didn't occur here. And two, it recognized that maybe akin but not quite a perfect fit for our case of Godberson, which deals with tax stamps. As long as they're allowed to be procured anonymously, there's no incrimination that accompanies it. I would again note that all of this discussion.
Well, and Herrera, it can't be anonymous because he's personally is asking for the cash.
Certainly, but he's permitted to basically. It sounds like avoid the implication. It sounds like he was given some sort of immunity of sorts to proceed with his claim.
Well, he got to get past it. He still was going to have to prove.
Sure, he had to make the requirement.
Yeah. At time of at the hearing, he was going to have to prove it was his money.
Certainly. Yeah. Again, I would note that our discussion of this case doesn't have to occur today for multiple reasons. One, neither of these errors, or I should say the categorical error was simply not preserved, and even under the as-applied, I should say it would be inapplicable or could not be used because the statute is not unconstitutional as it applies to Mr. Gibbs.
Can you address the argument that the instruction, even if it was allowable, this particular instruction may have been wrong? So if you look at our flight cases, there's an indication that flight may or may not be relevant, but at least it should be instructed to the jury so they understand the permissible inferences that could be drawn from flight. As I read it, Mr. Berger made a similar kind of objection where he was proposing language that would soften kind of the duty. Can you address that particular issue?
Certainly. I think the district court in this case was in a tough spot. I don't think it would have necessarily been incorrect for the district court to provide the additional language that Mr. Berger was requesting, but I don't think it was mandatory, and I don't think its absence altered the outcome. I would note that, again, it was a permissive inference as to what Mr. Gibbs's failure to report the statute or his decision to threaten other witnesses, if the jury found from the witness's testimony that occurred, what impact that would have on his claim that he was acting in defense of others. And I would again return to the fact of this is almost a star case for a harmless error analysis, especially given the conduct that was presented at trial, and it appears the jury rejected.
I want to take another stab. When I asked you about the instruction and you used my 321J example, as the defense counsel appropriately brought up, 321J taking the test is permissive. You don't have to blow into the machine. You don't have to. The way this statute's written, I believe, says the word shall.
It does say shall.
So isn't that a big fat difference?
No, Your Honor. I think there is a difference in that even though the ability to blow into a data master is permissive, one need not. there are sanctions that accompany that. I don't see them as analogous, or I should say distinct. So for the foregoing reasons, the state would ask that you affirm Mr. Gibbs's conviction. Thank you.
Mr. Howell, thank you as well. Ms. Stewart, you may present your rebuttal.
So I just want to address a few things. I do want to go back to the pre-arrest silence, pre-Miranda silence. There is an exception to that, and the exception is if you're being asked to give away one of your constitutional rights. And I think that's where this falls in line. Mr. Gibbs was being asked to give away his Fifth Amendment right to self-incrimination, and at the trial, the state obviously used that against him to get rid of his justification defense.
What if the instruction was lightened up, as Justice McDonald talked about? Sort of like the flight instruction, you can, but you're not required to draw this inference.
I think that would have gone a long way, and that is the second issue that we brought up, that the limiting instruction would have maybe added some assistance to Mr. Gibbs. But here, there was no limiting instruction like that usually comes along with the flight instruction. This was just the statute by itself.
What if the state argued there's no instruction, and the state argued Iowa law has a duty for you to report this, what the instruction requires, and he didn't? What's wrong with that?
Again, I think it goes to getting rid of that underlying justification defense that he's allowed to argue at trial, and that's essentially where things went wrong. I also want to talk about.
Can I ask you about your Iowa constitutional claim?
Sure.
When Griffin was decided, Iowa was noted as one of 6 states that did not prohibit an adverse inference instruction on invoking the right to remain silent at trial. And we had controlling cases up into that point in time saying the Iowa Constitution does not prohibit that, which I think would be the strongest form of that argument. Are you aware of any cases that have overruled our Ferguson decision on the Iowa constitutional issue?
I am not.
Okay.
But I will say, thinking back over those cases, they all went towards impeachment, I believe. So if a defendant is testifying, you could use those things against him to impeach him. And the difference here is the defendant wasn't testifying. And I also want to talk about briefly the categorical versus as implied for the preservation. I do believe, and I argued in my brief, that this was preserved. At trial, defense counsel did bring up a categorical argument for why the statute violated the Fifth Amendment, and he merely applied that to the facts of his case. He wasn't merely making an as-applied argument. And I think, without any further questions, I'll close, and I will ask that this court vacate Mr. Gibbs' sentence and remand. Thank you.
Ms. Stewart, thank you as well. Mr. Howell, thank you again. The case of State versus Gibbs is now then submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.